difficult to work directly around the structural issues in terms of the regulatory environment, which doesn't permit onshore, or has up until today not permitted onshore security to be given for offshore debt. There are, however, I think, ways to structure around that to a certain extent. Again, the market has been looking at various forms of sort of quasi-security, what have become known as keep-well sort of structures. I personally am a big fan of seeing, let's just say, personal pressure points be taken by offshore lenders. So I think people who are investing in these situations should be insistent on getting personal guarantees from the chairman, for example, or the family members that own the business, and taking real offshore security, if there's real estate in Hong Kong, for example. But collateral that has real value, if it is available, that can be utilised in the event of a default. I think, though, that the real key to being successful in these type of structures is actually really knowing at the outset who you're dealing with. And I think that the people that I think who have been most successful in this space, certainly in terms of the private deals, are investing in companies that they know, that they trust, and that when they commit the funds on day one, that is really just the beginning of their relationship, not the end. So they become, I think, very close to management. They know the business, understand the business, and continue to stay in touch on a regular basis so that they don't find any, let's just say, unwanted surprises. So I think that the lesson in all of this is that prevention's better than cure, and that being diligent at the outset through your credit process and then maintaining vigilance throughout the history of the relationship is the best way to avoid problems. Unfortunately, when it comes to sort of legal recourse, that is really perhaps the worst situation to be in. The legal recourse is imperfect still, and it's best to avoid that at all costs.